Good afternoon, everyone, and welcome. It's great to have you here with us this afternoon. Before we begin, I'd just like to take a moment to acknowledge the traditional custodians of the lands on which we're meeting today. I'm dialing in from Sydney, so for me, that's the Gadigal people, and I pay my respects to all elders past, present, and emerging. I also extend that respect to all Aboriginal and Torres Strait Islander people joining us today. This afternoon's webinar explores a question that sits at the heart of modern day family law practice: how the way we practice law can either escalate conflict or actively reduce it, particularly for children. Family law is structurally different from almost every other area of law. Parental relationships continue, children remain embedded in the system, and the strategies, language, and processes we adopt don't just resolve disputes, they shape family functioning long after proceedings end. Today's session invites us to reflect on how adversarial processes can unintentionally amplify conflict and how trauma-informed, child-centred practice can be applied in a way that is practical, proportionate, and aligned with both the evidence and the direction of the law. We are very fortunate to be joined by Gabriella Pomare. Gabriella is an experienced family lawyer and nationally recognised speaker whose work focuses on trauma-informed lawyering, child-centred practice, and practical system design in family law. We'll leave about 10 minutes at the end for questions, so please feel free to submit your questions through the Q&A chat box that you'll find at the bottom of your screen. And just to let you know, this webinar is being recorded, so you can watch it after the event. Without further ado, I'm going to hand it over to Gabriella.
Thank you, Dina. So today I really want to begin where I think every family law matter actually begins. Not with the Family Law Act, not with pleadings, not with strategy. It begins with a parent sitting in a chair in your office or on the end of a phone feeling really scared. They're not calm, they're not regulated, and they're not strategic. They're frightened they will lose their children. They're frightened they'll be misunderstood. They're frightened that one badly worded email or one allegation or one moment of anger will define them forever. And many haven't slept properly for weeks. Many are still in shock of their separation. And many are grieving the loss of the family that they never imagined losing. Many are even ashamed that they're sitting in your office. And in that moment, before a judge ever sees a file, the family law system has already begun. Because the first lawyer a parent encounters becomes, whether we like it or not, the translator of the entire system. Us lawyers, us family lawyers, we shape how dangerous the process feels, whether escalation feels necessary or avoidable, whether cooperation feels possible or naive, and whether the client feels empowered or shamed. So before a registrar even lists a matter, and before an affidavit is sworn, before any interim hearing occurs, the emotional architecture of the case has already been set. And this is why family law is unlike any other area of legal practice. Because in family law, the emotional experience of the process doesn't just sit alongside the outcome, it becomes a part of the outcome. And I think there's a truth that we don't say often loud enough in this profession. Families probably forget the exact orders that were made, but they never forget how the process itself made them feel. Years later, we don't have parents saying, it was order 4.2 that broke me. They say, I felt unheard. I felt humiliated. I felt like I was on trial as a parent. I felt like the system was against me. And the children, they don't remember the affidavits. They remember the tension. They remember the silence. They remember the raised voices behind closed doors at home, and they remember how their bodies felt at every single changeover. And family law really is one of the only legal systems where the process itself becomes part of a child's developmental environment. And I think once you really sit with that, it becomes impossible to argue that how we practice family law as practitioners and how we give advice from the most early stages just doesn't matter. So why then is family law so structurally different? Family law can't be practiced as if it were commercial litigation. I mean, in commercial disputes, the relationship, it ends at judgment. In criminal law, punishment creates closure. But in family law, the parental relationship, it must continue, often for decades, and children live inside the emotional residue of how that relationship is reshaped. Now, these aren't simply my views because what would I know, but realistically, it is embedded in Australian law. And when the High Court made it clear that parenting arrangements must not only be in a child's best interests, but also reasonably practicable, it was recognising something really fundamental. Parenting orders, they're not abstract expressions of fairness. They're actually predictions of human behaviour under stress. So workability, or reasonable practicality as we call it, of parenting arrangements or parenting orders, it's not just a convenience issue. It really has to be a child safety issue. And an arrangement or an order that looks principled on paper but collapses ultimately under conflict and distance and poor communication or parental dysregulation, that's just not child-focused. And yet despite this, much of family law still defaults to adversarial reflexes. I mean, escalation continues to be treated as strength amongst practitioners. Aggression is treated as advocacy, and conflict is treated as proof of commitment. And this creates a really deep contradiction because we say that we act in children's best interests whilst using processes that amplify the single greatest risk factor identified in decades of research. And Australian research in this area is really clear. And as family lawyers, we need to start taking note. The Australian Institute of Family Studies has been studying children's outcomes following parental separation for more than 2 decades. And across longitudinal studies and population data, post-reform evaluations, there's one finding that is consistent. It's not separation itself that harms children. It's ongoing, unresolved interparental conflict. And children exposed to chronic parental conflict show significantly higher rates of anxiety and depression, emotional dysregulation, behavioural difficulties, sleep disturbance, concentration problems, and long-term relationship insecurity. And by contrast, children in separated families with low conflict show outcomes comparable to children in intact families across many developmental indicators. It's not research. This really is foundational, and it really has profound implications on how we practice and the way in which we practice and the advice we give our clients. So if conflict is the primary risk factor, then any professional action that escalates conflict is actually increasing the risk to children. And this includes how we draft letters, how we frame allegations, how we advise on urgency, and how quickly we reach for court. And the Australian Institute of Family Studies evaluation of the family law reforms, which was one of the largest empirical evaluations of a legal system ever conducted in Australia, found that families with high levels of legal system involvement experience longer disputes and repeated litigation, more entrenched positions, and poorer emotional outcomes. And it wasn't because the law was wrong, principle, but it was because adversarial processes sustained fear and mistrust and identity threat. So in other words, more litigation often meant more conflict, not more resolution. So I guess the question is, does the way in which we practice actually create and heighten conflict for our clients? Let me describe a pattern I'm sure every family lawyer listening today has seen. A dispute begins over something really manageable, school holidays or changeover logistics or extracurricular activities. The first legal response is a long letter, and it often includes a really long history. Accusations framed as concerns, references to failure, lack of insight, and deadlines framed as ultimatums. And from a legal perspective, this feels thorough. But from a psychological perspective, realistically, we know it's intended to stir, to heighten conflict, to inflame, and to put across our client's case. But neuroscience tells us that when a parent perceives threat, particularly threat to their parenting, their ability to reason and empathize and their impulse control diminishes. So it doesn't come down to pathology, but everything we do in family law is actually biology. the receiving parent who gets the letter either fires back with equal intensity or shuts down completely. And then silence is interpreted as power, and power is interpreted as danger, and affidavits follow, and the language between lawyers and practitioners hardens, and positions moralize. But the reality of that is the child becomes involved without choosing to, and that often turns to guilt, shame, choosing between parents, and this creates anxiety. And nothing about the child's needs has changed, only the process has changed. And this is what I call process-induced conflict. And it's far more common than I think as practitioners we like to admit. And this leads me into really talking about a process that I refer to as trauma-informed lawyering. And I think trauma-informed lawyering, it's often misunderstood. It doesn't mean being permissive. Trauma research shows that people... Yeah, Dina?
Sorry, did you break up for a minute then?
Oh, I can...
It might have just
you
on
tell
my
me.
screen. Okay.
No, you're right.
Let's carry on. Sorry about
Let's
that.
keep going. No, you're right. Let's go back a bit, okay? So trauma-informed lawyering, and I think it's often misunderstood. And it doesn't mean being permissive or avoiding boundaries, and it doesn't excuse harmful behaviour. But what it does is it means understanding and acknowledging what human behaviour actually does under stress. And this is really important because trauma research shows us that people experiencing relationship rupture often display hypervigilance, black and white thinking, fixation on fairness, and a reduced tolerance for ambiguity. And we all see this. We see this every day in our clients. We see this on, the parties on the other side. And in family law, I mean, this presents as an obsessive focus on detail, moral absolutism, an inability to compromise, and excessive documentation. Again, we see this every day. But lawyers sometimes label this as manipulation, but realistically and more often, it's fear. But the Australian family courts are now really starting to recognise this reality through things like the risk screening tools, the Lighthouse Project, and specialist lists for high-risk matters. But realistically, the most powerful trauma-informed interventions occur before court, with us as the family lawyers, and in the way that we advise and the way we represent our clients. It occurs from the very first intake, through our advice, through the correspondence we send, and through negotiation. And realistically, and if I could get one thing through today, it's that containment is the true key skill. In essence, from the very first conference, every lawyer is teaching their client something about the family law system. I mean, we're teaching them whether cooperation is going to be seen as naive, whether aggression is really necessary, and whether fear is justified. And we know that clients mirror us. I mean, if we escalate, they escalate. If we regulate, they regulate. And this is systems power. And as family lawyers, more than anyone else, we are setting the cultural tone of our jurisdiction. So really, is the law moving away from conflict, or are we as lawyers heightening it? And I think this is where we need to talk really honestly about legislative intent. I mean, the pre-action procedures, they weren't introduced by accident. They were designed to require early disclosure, to encourage negotiation, to limit surprise, and to reduce unnecessary litigation. They weren't just bureaucratic hurdles. They were conflict containment mechanisms. And the more recent amendments to the Family Law Act continue this trajectory. They simplified the best interest framework, they reduced misinterpretation, and they recentered safety, practicality, and the lived experience of children. And the direction of the intent behind the amendments, it's clear. The system is trying, albeit imperfectly, to move away from adversarialism. But lawyers who continue to practice as though escalation is the default, they're not being better or stronger lawyers who are going to gain a better advantage for their clients in a matter. What they're doing is actually practicing against the grain of the Family Law Act itself. So at a practice level, this really requires a shift. Family lawyers, we're not just advocates, we are ultimately system designers, because from the moment we take on a new matter, Every file that we work on needs to establish from the outset really clear communication rules, response time frames, escalation pathways, and dispute resolution before litigation. And we need to be teaching and guiding our junior lawyers these practices from their earliest days with us. So some practical tools for better family lawyering needs to include things like regulation checks before escalation, language audits to remove shame-based phrasing from our correspondence, containment letters focused on proposals, not on historical narratives of who did what. We need to coach our clients on time and tone and restraint. No more sending out letters at 5 p.m. on a Friday. It's not healthy for anyone, including us as lawyers. And embedding dispute resolution clauses that actually function. And these shouldn't be seen as soft skills in lawyering, because what they really are risk management strategies for a client. And as family lawyers, yeah.
I was just going to say, in your practice, how does a regulation check, what does that look like?
I think what we need to do is work out where a client is at in their matter. And we start by testing the risk as opposed to the fear that they're experiencing. And when someone comes to me with a problem, your initial reaction is, let's draft up a big letter. Let's put everything in there. That's the old blame game. But is that really going to get the outcome a client wants? Or do we contain and regulate what the issue is, put proposals forward to resolve that issue as opposed to just that blame game?
And then I guess the sort of follow-on point from that is, I think we also need to take a personal regulation check of, say, is now the right time for me to be dealing with this? Am I too emotionally invested in this? I remember a particular stoush I had with another lawyer about holiday arrangements, So in that circumstance, I had to take a step back and say, okay, I need to come with a clear head to this issue. I need to give it a day before I sort of do anything further with it.
And I get that all the time, especially on a Friday afternoon. If I get one of those aggressive letters, I start taking it personally. So I think half the time I don't send it to my client on a Friday afternoon because it's going to ruin their weekend. They're going to be contacting me all weekend, and it's an issue that we can deal with next week. I think that practice really needs to change. So I think where that leads me then is I really want to talk about this idea of separation as an identity rupture, because realistically, as family lawyers, we are tasked with the responsibility of shaping our client's experience. And in doing that, we really need to remember first and foremost that separation itself, it is this concept of an identity rupture. And I've been through it, I get it. Parents are losing, certainty, confidence, their future narrative. And the reality is that many disputes persist, not because of the arrangements, but because of this identity rupture. Because separation isn't only the ending of a relationship, it's really the loss of identity as we know it. And for many parents, particularly those who have organized their adult lives around partnership and family, separation, it destabilizes the internal narrative of who they are. Roles that once felt really secure, they were the spouse, they were a partner, they were part of a family unit, and that often it fractures overnight, and the certainty about their future collapses. And I think the imagined trajectory of, going to school events and holidays and sharing milestones and of aging together, it all just disappears suddenly. And so in that vacuum, parents often experience shame and fear and anger and a profound loss of meaning. So it's not really just emotional distress, it's a complete disruption of identity coherence. And when identity feels threatened, the nervous system interprets that as danger. And then behavior becomes defensive and rigid and combative. And we see that every day with the people that we work with. And in family law practice, this identity rupture, it frequently drives litigation more than the practical dispute itself. Arguments about time arrangements, decision-making, minor variations, it actually masks a much deeper fear. Who am I now? And if I'm not in this family the way I once was, what now? And so realistically, litigation becomes an attempt to restore dignity, to control or validate, rather than to actually resolve a child-focused issue. And when practitioners recognize identity rupture as an underlying dynamic, our advice becomes more strategic and less reactive. And by stabilizing parental identity through really clear advice, and realistic expectations and pathways that actually preserve the parental role and competence, we actually see conflict reduce. Not because the legal issues have changed necessarily, but because the parent no longer needs that litigation to feel whole again. And the problem really is when parents focus on litigation being a way of restoring, meaning in their lives. But what we know is that when identity stabilizes, conflict reduces. And that's because the parent has changed.
Gabriella, I think you might have, there might be another issue with the connection. Okay, we seem to have lost Gabriella. Just give us a minute and we'll try to get her back on the line, but she might have an unstable connection. So just bear with us. Apologies for this. I think we have you back now. I think it did drop out just for a minute, but
Yeah, I can't tell, sorry.
Unless it's my computer, but I'll pass back to you.
No, that's okay. I mean, I have no idea where I left you, but I think what we're talking about realistically is the idea that litigation restores meaning to clients, and it's only when their identity starts to stabilize that that conflict then reduces. So I think one of our most important jobs as lawyers is, assisting parents beyond survival and into that new role, a new part of their life. And that's realistically because we know that family law will always involve loss. But what the evidence tells us is that it doesn't need to cause lasting harm. And so if we start focusing on conflict as the primary risk factor in assessing any matter, then our professional duty really is clear. We need to reduce conflict, we need to increase capacity, and we need to protect children. And that really is the future of the profession. And although I think the law is changing in many respects, our professional habits and practices, they just haven't caught up. Because when we step back and when we carefully look at the last decade of reform, and especially the last amendments, a very clear message emerges. Our family law system really is trying to de-escalate conflict, and it's trying to push us away from adversarial reflexes. And it's doing that, whether we like it or not, through the reforms and the pre-action procedures and a push towards mediation and collaborative practice. But we continue to see a really common justification lawyers are giving for escalation. We hear things all the time. The system's adversarial and I have to protect my client. But that statement, it only really works if it's true. And increasingly it isn't. And pre-action procedures and the structure of parenting litigation, the changes to best interests, and the way courts now talk about ability, it all points in the same direction. The system is asking us as lawyers not to inflame conflict. It's asking us as family lawyers to contain it. But what I see every day is that the pre-action procedures continue to too often be treated as box ticking, send a letter, make an offer, threaten proceedings and move on. But that really misunderstands the purpose, because the pre-action procedures really exist for four things: to slow parties down before escalation, to force proportionality, to limit surprise and ambush, and to encourage early resolution where safe to do so. They weren't designed to be hurdles on the way to litigation. They were designed to prevent litigation where litigation will actually make things worse. And so when pre-action correspondence becomes performative, long, accusatory, moralized, it actually does the opposite of what the rules intend. It escalates threat, it entrenches narratives, and it hardens identity positions. And courts can see this. And senior practitioners, we know this already, judges are increasingly intolerant of correspondence that exists purely to posture. And if you read parenting judgments closely, particularly over the last several years, something really has changed in tone. Judges are no longer just deciding disputes, they're commenting on the conduct of litigation, on the proportionality of steps taken, on the impact of conflict on children, and on the failure of adults to regulate themselves. I think the problem is that the recent amendments to the Act were widely misunderstood too early in commentary and in the way that lawyers continue to advise their clients. Too many lawyers saw them as technical or political or as symbolic, but they're none of those things. They're actually really directional. They simplified the best interest framework, they reduced misinterpretation, and they centered the safety and practicality and the lived experience of children, which is the most important thing in family law. I think most importantly, they moved the focus away from the abstract parental entitlement and towards really real world functioning. And the question no longer amongst lawyers should be, well, what can I argue in court? What can I put in an affidavit? It needs to increasingly be what will actually work and what will actually reduce harm for this family. And I think the uncomfortable truth is that when lawyers escalate unnecessarily and when they moralize correspondence and we rush to interim hearings as leverage and we frame every single issue as urgent, we're not just increasing costs for our clients, we are practicing against the grain of the Act. Because the system is telling us through the pre-action rules and the amendments and the judicial commentary that adversarial reflexes are no longer neutral. They're risk factors. And I think proportionality isn't just about costs. What it needs to be is about the emotional toll on children, the sustainability of outcomes, and the biggest thing, the capacity of parents to co-parent once us as lawyers leave. Us as family lawyers, we've got a real obligation to model this proportionality. It's the safest thing to do. So then I get asked all the time, what does a practitioner reality check look like? And I think we all need to ask ourselves honestly, how many of our files escalate not because of risk, but because of fear? And how many affidavits were drafted not because they were necessary, but because the silence felt a bit intolerable? How many interim applications were driven by our clients' distress rather than by a genuine forensic need? It's not about blame or blaming practitioners, but it's about recognizing that lawyers actually were powerful amplifiers for better or worse. And so what does that alignment actually look like in practice? Well, it looks like shorter and clearer pre-action letters, fewer narratives, proposals, earlier use of dispute resolution where it is safe to do so. I think realistic advice about what courts actually care about when we're drafting, and the containment of client emotion before escalation. And that is what I think modern family law practice is. And realistically, it's increasingly what the courts expect. As family lawyers, we're not just advocates, we really are the designers of a whole post-separation family system. And one of the most important professional judgments a family lawyer makes is not which orders to seek, but which pathway best reduces risk for the children involved. Now, I know that collaborative law isn't appropriate in every matter, and it's not a replacement for protective court intervention where there are serious safety concerns. But when used intentionally and early, it can be one of the most effective tools we have to de-escalate conflict and to preserve parental functioning. And collaborative law really is most powerful in matters where conflict is high, but risk is manageable, and where fear and grief and identity threat are driving behaviour. And these are often the cases where litigation would technically be available, but would predictably escalate hostility and entrench positions and increase emotional harm to children. And in those circumstances, collaborative law offers something litigation can't: a structured environment that reduces threat, limits performative conflict, and keeps parents focused on problem solving rather than winning. And from a child-focused perspective, the strength of collaborative law lies in the capacity to contain the conflict and rather than amplify. And positional posturing reduces parental dysregulation. And the presence of really clear ground rules and shared commitments and interdisciplinary support allows parents to remain engaged as decision makers rather than adversaries. And for children, this often translates into lower exposure to adult conflict and more stable routines, and parents who are better able to regulate their emotions during and after separation. That is so important. And importantly, collaborative law aligns closely with the direction of contemporary family law reform. The emphasis on proportionality and early resolution and practical outcomes reflected in pre-action procedures in the recent amendments. That's mirrored in collaborative practice. Both recognise that how decisions are made matters, not just what decisions are made. And when parents are supported to negotiate in a really contained and respectful process, the resulting agreements, they're often more durable, they're more workable, they're less likely to require future court intervention, and they're outcomes that directly benefit children. And that's what our practice needs to be all about. Children while preserving parental capacity. But it does require careful assessment. Dina, can you hear me? Yeah, sorry, it keeps saying internet unstable, so I'll just check. I think looking at collaborative, there's sufficient appropriate report and safely within a collaborative framework.
Yeah, I might just get you to start
collaborative
at the. You did break up just a bit then, so I might just get you to start back at the top.
All right, let's go back to, for lawyers, and when we recommend collaborative law, it's not just a retreat from advocacy. What we need to look at is as a strategic, evidence-based decision about how best to protect children while preserving parental capacity. And it requires really careful assessment. So as I just said, are both parties actually able to engage in good faith? Is there sufficient emotional regulation with appropriate support? And can power imbalances be managed safely within the collaborative framework? And when the answer to those questions is yes, collaborative law can shift the family from escalation to stability. And it's not because we're avoiding the hard conversations. It is designed to reduce harm. Ultimately, family law prioritize the child's lived experience, we're not only resolving disputes, we're actively shaping healthier post-separation family systems. So then what else can we do practically as family lawyers? And in my view, I find to be judged early, not literally, but emotionally. Emotion is such a big part of family law. We need to ask ourselves, is this client, is there untreated trauma? Is this identity threat or a genuine risk? And will litigation stabilize? And this informs path selection. Not every client needs to persuade, some need to contain. And containment letters need to acknowledge, they need to anchor child-focused principles, they need to propose options, they need to set clear next steps, and they don't need to rehearse history necessarily. So when a client comes to us, and before escalating an issue a client's raised, we should ask ourselves, what harm does escalation prevent? And what harm does escalation create? And is this actually about risk or is it about discomfort? And as senior family lawyers, we need to start teaching our juniors this discipline, because this ultimately will result in parents who are better regulated, who litigate less, who co-parent better, and who comply more consistently with orders and parenting plans. So as I said earlier, we know that family law will always involve loss. Separation is always going to change the shape of families and dynamics. It changes routines and finances and identity and expectations, and that reality, it can't be removed or changed by the legal process. But what the evidence makes clear is that loss itself is not the primary predictor of long-term harm to children. As I've said lots today, ongoing, unresolved parental conflict is. Conflict is the greatest risk factor. And conflict, unfortunately, it's not just a simple feature of parties. It's influenced and significantly by the way the legal process is structured and conducted. The process itself is what escalates threat perception, entrenches positions, and prolongs hostility. Or we can allow it to create predictability and reduce uncertainty and support workable outcomes. We're not, as family lawyers, just neutral observers within our system. We're actually the active participants in shaping it. Every professional decision we make has downstream effects, whether we characterize conduct as malicious or misguided, whether correspondence is framed as accusatory or solution-focused, whether urgency is proportionate or reactive, and whether litigation is positioned as a last resort or a tactical tool. And these decisions affect not just the legal trajectory of the matter, but the entire emotional trajectory of a family. And so I think the question then is not whether a practitioner identifies as adversarial or collaborative. I think that framing is overly simplistic. But I think the more relevant question is whether our approach as a family lawyer produces effective outcomes in the real world. And what does effective mean? It means orders that are workable, reasonably practicable, arrangements that parents can implement even under stress, a reduced exposure of children to ongoing hostility, fewer repeated proceedings, and greater parental compliance. And I think the recent legislative reforms, including, as we said, the refinement of the best interest framework, reflect that clear shift in direction. The system is encouraging early resolution and it's discouraging unnecessary escalation, and it is prioritizing safety and workability. And so our practice and the way that we advise clients has to start aligning with that direction. It doesn't require less advocacy on our part. It requires really disciplined advocacy. And I don't think it requires less protection where risk exists, but it requires a clearer distinction between genuine risk and emotional reactivity. Too many lawyers think it requires abandoning litigation, but again, I'm not saying don't litigate. What I'm saying is use litigation proportionately and strategically. And if we accept, I think, that the conflict is the primary risk factor for children, then I think realistically a really uncomfortable question follows. Are current professional accountability mechanisms strong enough to address the conduct that escalates it? Ongoing reform can't focus solely on statutory language and procedural redesign. It must also examine professional behaviour. And if adversarial reflexes continue to drive unnecessary escalation through disproportionate interim applications and performative correspondence or tactical urgency, then the system will struggle to achieve its stated objectives. And a more explicit emphasis on practitioner responsibility might be required. And that might include stronger judicial scrutiny of litigation conduct and clearer consequences for disproportionate steps, and more consistent use of cost orders where behaviour demonstrably increases conflict without advancing child-focused outcomes. It's not about punishing robust advocacy, but it's about reinforcing proportionality and ethical alignment. As family lawyers, we're already bound by duties to the court and the administration of justice, but in a jurisdiction where process directly affects children's lived experience, those duties carry particular weight. Reducing conflict, it's not just a therapeutic preference, it's actually an ethical responsibility, and it's grounded in evidence and research. So I think where practitioner conduct exacerbates hostility and it prolongs disputes or it weaponizes the process, it's reasonable to ask whether stronger accountability mechanisms should follow. Because I think reform, it's not just legislative, it's cultural. Senior practitioners set the tone, and firms, they shape internal norms, and mentorship of junior lawyers determines whether younger lawyers learn to equate escalation with strength or risk. So if we want better outcomes for families, reform needs to extend beyond the Act and into the profession itself through clearer expectations, much stronger supervision, and where necessary, more meaningful consequences. It's not about being softer as lawyers, but I think it's about being more effective because the law is evolving and the research is really robust and judicial expectations are shifting, but the profession, it really needs to evolve with it. I think that's where I want to end today because it really does sit on us as practitioners.
And I guess I'd sort of just have a half question, half comment. And I really like how you referred to it as adversarial reflexes, because I think that's sometimes what it is. We sort of default to these older habits. And, as juniors, you're reading the correspondence of the senior practitioners, and you're seeing these references to, going to seek indemnity costs against you and your client, and failing hearing a response from you, all these really sort of loaded language. And I guess I think sometimes practitioners can think, well, if I remove all of that, am I sounding too soft? And I think what you were saying is that it actually has the inverse effect. It doesn't produce better outcomes. It produces worse outcomes.
Yeah, and I
Um,
think it's the
what
balance.
I was just going to say, what advice would you give to someone who they're dealing with an opponent who is very brash and uses that loaded and adversarial language?
I think our immediate reaction is fight back, right? And let it back that's just as aggressive. And I'm guilty of it too. But the reality is the calmer tone you use and the more neutral you are in your correspondence probably is just going to enrage them even more. And we need to slow things down and we need to keep at the forefront of our minds that this isn't about who's right or wrong. It's not about winning. We actually have children, if it's a parenting matter, that are at the forefront of the decisions being made and they need to be protected. And heightening the conflict between that child or children's parents is doing no good and no, better for them, because the reality is mum or dad will be at home, they'll open their emails, they've received one of these letters. Can you imagine the state of that mother or father after reading a letter like that? How are they supposed to parent for the rest of the day or for the night or for the weekend when you get it on a Friday? And I think also as lawyers, it's setting proper expectations for your client. And when, we very quickly say we want a response by 12 p.m. tomorrow, we're filing in court, and I've done it. And I'll have a client ringing me up the next day saying, great, it's 12 p.m. and we didn't get a response. Are we filing? They think they're filing because that means a win, and it often doesn't. It means increased costs, and it means longer, heightened conflict. We need to really balance what the right approach is.
Yeah. And I know everyone sort of harps on about this, but I think it's not really been picked up. It's, the simple act of picking up the telephone and calling your opponent, even if you are sending a nasty letter, just to sort of, I guess, to lighten the load, but to also, if you've received a nasty letter like that, like, what's up? Why am I getting this? We should have just had a conversation about it in the first place.
What is the true issue? And often I think, as I said, is it's emotion. There's a deeper emotional something is going on within that person who wants to send the letter, and half the time there's a resolution available. There's a very simple proposal that can be made to de-escalate things, but we jump to the conclusion that sending one of these letters, we're showing off to our client, we're spending their money well, but that often isn't the case. So it's really making the right judgment call and guiding your client too sometimes as to why you haven't been more aggressive in a letter. I've had heaps of, lots of phone calls from clients saying, can we make it a bit more aggressive? Can you be a bit more firm? And realistically, I'll do it if I'm absolutely instructed. But the reality is it's not going to serve the purpose the client ultimately wants, which is to long-term co-parent better.
And I guess that's the sort of advice you have to be giving the client is, yes, I can do this, but it is actually not going to help your case at all.
Mm. Mm. Do you want to be forever, or do you want to be effective co-parents and actually work together in making decisions for your child? Or
you were just talking about sort of how do you determine when an issue is genuine, or when I guess the fear or concern is, I guess the concern of the client is increased really more by their fear or that identity threat or their loss of control. Like, how do you work out what their motivating factor is?
I think it's all about taking time in client conferences. So it's not getting an email and, hey, this happened on the weekend, XYZ, great, I'll draft a letter. We'll tell them this is what happened. Again, we'll express the concern. We'll tell them about their lack of insight and poor judgment. But sometimes we need to sit back and say, Give me the whole story. What conversations were had prior to the event that took place? Where are you at? How are you feeling? Because you'll find that ultimately there's a greater context. There's something else going on that's driven a client to want to send you an email. And that might just be, again, where they're at in a separation, that healing journey that they're on. Or it could be that something's happened. And I often experience that when people start to repartner. And when new partners, for example, are introduced to children, other parents will start finding issues and finding concerns and risks, again, to escalate. And the reality is, let's all just sit back, work out what the actual issue is, and let's find a resolution that focuses on your child. And that can be hard, and it is very hard for separating parents to do that. But I genuinely feel that sometimes as lawyers, we do make it worse.
And I think that's exactly right. When people are in the thick of it, they're not thinking logically. And a criminal lawyer friend of mine said that a really interesting adage: criminal law is bad people at their best, and family law is good people at their worst. And that has just always stuck with me.
Yeah, yeah. We see them at their worst every day, and it's often when I check in on a client a year later or 2 years later, and I hear that they're getting on really well, I say, wow, as soon as the litigation stopped and the lawyer stepped away and the letters weren't being sent back and forth, these two actually started to get along. And that's why I'm trying my best these days to encourage people to move out of the system, to get it done, to themselves negotiate an outcome that they can live with, and that will be workable so they can move forward in that post-separation relationship.
And how important do you think family therapy is in this process? Do you find it helpful with your clients?
I'm a very, very big believer in it, but it takes two people to want to do it, and that is often the problem. And you'll often find that you have one party who's encouraging it. And again, it needs to be done for the right reasons. Don't encourage family therapy for the sake of some orders, for the sake of looking good in court. You will very much know when there's a family in need of it, because I think what we find, and you will have found in your practice, is that half the time issues, particularly relating to parenting, are nothing that a judge or a lawyer can fix. They're largely communication issues. They're to do with conflict, and they're to do with making decisions. And we can have the best set of orders, but no set of orders is going to help families work together once us as lawyers are gone and maintain that relationship, because decisions still need to be made a year later and 5 years later. And so working with a really good family therapist provides that safe space to be able to work through those communication issues, to work out what really is going on between us as parents and how can we fix that. And I think the beauty of that therapeutic relationship where it remains untouched is that you can come back in a year or two when there is an issue, or there may be a small breakdown in that co-parenting relationship. And again, the default shouldn't be let's go back to the lawyer and send a letter 2 years later. It should be let's use our family therapist or parenting coordinator, for example. There are different things than tools that parents should be using away from lawyers. And yeah, I know it means we make less money, but that can't be at the forefront of our minds as lawyers all the time. Although, yes, we run businesses, we chose to be in a practice area where we are shaping families' lives. So costs need to be, secondary, and helping families still needs to be number one.
And I guess it means doing more. If you're taking that work away, you're doing more meaningful work, hopefully.
I would hope that that's why we're all doing it. Exactly.
I think you briefly touched on language audits. Can you give us an example of how you would, I guess, A, call a client out on that, and B, what are some actual practical changes that you could make?
Yeah, I think I see that a lot, and I see it in junior lawyering big time, because you'll get an email from a client saying, "I want you to put this in a letter," and you'll automatically write that. You'll write it up, but I say sit back and say, if you were receiving this letter, the tone, the language you use, how would you react? Do we want the person on the other side to become defensive straight away, then to heighten that conflict, or can we just let them know what the issue is and instead change the language, change the tone, and focus on the proposal to move it forward and to fix the issue? So I do a lot of that, at least in my practice, of shifting the way my junior lawyers write their letters, shifting the way that perhaps we communicate with the other side, not always, but a lot of the time. And I think in terms of clients, and I know it adds to the stress of our job, but what I often say to them is before you send emails and texts, I have no issue with you forwarding them to me. I know it's an old practice, but if you think what you're about to send is simply going to heighten the conflict and I'm going to get a letter about it on Monday, just flick it to me. put all the terrible language and all the emotion in an email or a text, send it to me. Either I'll reword it for you, or let's just forget that. You've been able to let it out, right? You've sent me that email, all the anger's come out, and now rewrite something calmer and send that to your ex. And sometimes that's the best thing for them. And then you've got to weigh up, do I charge my client for this or not? And I know a lot of that comes into it, but we're still here trying to fix a family. And I think the good thing too, though, these days is apps like Our Family Wizard do a lot of that now. They've got all that regulation with the AI, and they'll tell you when you're too aggressive or you're, guilt tripping your co-parents. So that's really beneficial these days too.
Well, I mean, that is actually a good point. You could feed it into the chat box, but the only thing to be aware of is the automation and confirmation biases.
I did have a cross-examine in a matter last year at a trial where unfortunately one of the parents left that last line in saying this was AI generated and was made more collaborative. And so just take that one out.
Yes, I mean, there's only so much we can do as practitioners.
Yeah.
Okay, so looking 5 to 10 years ahead, what do you think needs to shift the most in the family law culture and the practice to truly align with what we know about children's well-being?
I genuinely believe, as harsh as it is, that there does need to be better machinery tools in place for us as practitioners. And I know we have cost orders and I know we've got all our ethical obligations, but until we start being called out on our behaviour and the way we practice, it will just continue. So a bigger focus, obviously, we are already on mediation and collaboration and collaborative practice to an extent. Again, I think that needs to be finely balanced because there is no point forcing people to do 5 mediations because that often just escalates conflict as well. So I think there needs to be a better measure and balance within the court when it comes to that. But I really think there needs to be stricter protocols in place for how we practice. And again, the tone, the language, when we rush off to interim hearings and when we use litigation to resolve disputes, better education, much better education on that. And I think as the junior lawyers, start rising through the ranks, they'll learn from that.
And I guess it seems like we need another Simich Norton case, and I guess more focused towards children and how it affects their outcomes.
Well, yeah, I don't know the costs have necessarily changed through all that. I think things are getting more expensive, but I do think that we just need a bit more forced education on the issue because the reality is until we actually see how it's impacting children, we still don't get it. And I think perhaps more social science coming into play realistically on that long-term impact. Because social science, it does tell us, and I do genuinely believe it, that how a child experiences their parents' divorce, and I speak about this a lot, that is what shapes their future trajectory. And that is, how they then go into marriages and adulthood and how they parent. And we need to know and keep that at the forefront of our minds when we're lawyering, because we are directly responsible for that child's future and how we help their parents divorce, whether amicably or not. We were having the largest impact on their future, and that's got to mean something.
Yeah. I think that's definitely a really valid point. I have a friend who had her parents went through a terrible divorce, and she talks to me about it and how 15 years later, she's still scarred by it. And I guess I'd never really thought about it from the perspective of the child as opposed to from my own client.
Absolutely. I think what shifted everything for me and really made me extra passionate about this area is I had a matter last year where we had a child inclusive mediation, which they're starting to become a bit more popular. And although the children aren't there, they obviously work with the child inclusive practitioner. And the feedback we got from that practitioner was a 15-year-old boy. Suicidal, depressed, anxiety. And he was asked why. And he said, I don't want to go to school. And I used to love school. And I don't want to hang out with my friends because my parents' conflict is so high. When I'm at mum's, all she does is speak terribly about dad. And when I go to dad's, it's nonstop about mum. And it's ruining my life. And I read this 1-page report and it genuinely broke my heart because I said, how do these two parents not sit back and see that this is just doing harm, this process? There was no need to be in the court system. They were arguing over a 15-year-old. But the lawyers, and I was one of them, aren't doing anything to fix that because I'm arguing my client's case, which I'm obliged to do. If he wants to go to court for a 15-year-old, then so be it. I can only give so much advice. But once you read a child inclusive report with that kind of feedback, you sit back and say, can we all just sit down now and really focus on what this boy needs?
Yeah.
So it's hard.
It is hard, and I don't know if it will be answered in a day or in 5 to 10 years. But I guess the more aware we become of it, hopefully the better it will become. And I think what you're doing in this space at the moment is so great. And just to give you a plug for everyone listening, Gabriella has just released a book, The Collaborative Co-Parent. So if anyone's interested in getting a copy, we can send you a link to purchase it. And if you're interested in hearing more about this topic, Gabriella has spoken about it at length. So if you just Google her, you'll find her all over the internet. But this has been so invaluable. I was taking lots of notes as you were talking, so thank you. And I think it's just very helpful for practitioners to start turning their minds to these issues, and I guess that the trauma-informed approach, and just how can we de-escalate, and the conflict. I think that was really one of my biggest takeaways, is that it's the conflict that's the issue, not the actual process, and how we sort of as lawyers can make that worse, and we have to do better in the future.
Absolutely.
All right, well, thank you so much, Gabriella. We do have some more webinars that are scheduled for late March. We do have our Family Law Conference coming up on the 27th of February. So if you haven't registered, there is a wait list, and hopefully we can find places for people. Otherwise, we'll see you at the next webinar. Thank you,
Thanks for
everyone.
having me.
Thank you. Oh. Sorry. There we go. And
Thanks,
there we
Dina.
go.